an appeal in the matter of Valuation Office Agency, Dawn Bunyan and Fridays Limited.
Yes, Mr. Williams. We've read the decision of the Upper Tribunal, we've read the skeleton arguments, and we've looked at the authorities.
Very grateful, my lord. May I introduce my learned friend, Mr. Ormondroyd, who acts the respondent ratepayer, and sitting behind Mr. Ormondroyd is his pupil, Miss Rowland. My lord, we have agreed a timetable, outer limits in light of what your lordship's just said, that I'll complete by 12:45 and my learned friend will complete by 3:45.
Right, excellent.
The issue, as the court will have identified, relates to the exemption for non-domestic rates for agricultural buildings, and the primary issue within that is the extent to which there must be a functional connection between the building and the agricultural land it is occupied together with for the exemption to arise. The tribunal said no, the previous case law said yes. My lord, the structure of my submissions is in 8 parts. Firstly, the facts. Secondly, the grounds of appeal. Thirdly, the relevant legislation. Fourthly, relevant case law. Fifthly, the tribunal's decision. And then submissions in 3 parts. Sixthly, on the occupation test. Seventhly, a response to my learned friend's alternative argument on the occupation test. And eighthly and finally, submissions in relation to the use element. In light of the court's indication, I'll move on at any point if I'm covering ground.
Yes, well, I think you don't need to go through the facts in any detail because the facts are as the UT found.
Understood. My lord, in that case, the grounds. Page 15 of the core bundle. The grounds of appeal raise 2 issues of interpretation. What's the correct interpretation of the 2 elements of the exemption for agricultural buildings? That is, as I've set out in those grounds.
Yes.
And I identify these as 2 separate elements. The test of occupied together with and the test of used solely in connection with. And I identified as a specific ground of appeal whether the tribunal was right to distinguish the interpretation of occupied together with that had been set out.
Yes, well, you say Hamilton and Buxted still governs.
Exactly so.
Yeah. Well, we've understood that as your point.
And I may say the case does have wider implications than the instant set of facts, particularly in relation to facilities in the agricultural sector that are centralised in order to store, handle, pack and distribute goods as the intermediary stage between the agricultural production process and the ultimate retail process. The third topic is the legislation. If I may ask the court please to look at tab 7 of the authorities bundle. This sets out the law as it presently stands. Page 33, paragraph 1. This makes clear that the exemption applies to both agricultural land and agricultural buildings, and also the words "to the extent that" in the first paragraph make clear that it's possible to have partial exemptions, so within the same hereditaments, some buildings which are exempt and other buildings which are not. Paragraph 2 on page 35 provides the definition of agricultural land, which includes, as relevant in this case, but also generally, arable land in A, land used for poultry farming in C, and also in E, land that's occupied with and used solely in connection with the use of a building, which is an agricultural building by virtue of paragraphs and then specifically 4, 5, 6 or 7. The court may note paragraph 3, which is the central paragraph for this appeal, is not included there. And that's because paragraph 3, as we'll see, effectively addresses buildings that are ancillary to agricultural land. And so there's no need to define agricultural land by reference to the building. The land in question will already and necessarily be agricultural land by virtue of another provision in paragraph 2(1). Paragraph 3 is on page 37. I understand and appreciate the court has read that and identified the two limbs.
Yeah, and that's the central paragraph that we are interpreting.
It's the central paragraph in that it's the paragraph upon which the exemption is claimed.
Yes.
It is relevant in my submission to have regard also to the structure of the schedule, and also I would like to draw the court's attention to paragraph 5, which is on page 41, which deals with livestock buildings. You'll have seen from the skeleton arguments that this provision was a response to the House of Lords decision in the Herod case relating to poultry sheds and intensive sheds for housing poultry, which in that decision were found not to be an agricultural building, and this is the legislative response.
But the buildings that we are concerned with, is this right, are not used for the keeping or breeding of livestock.
That's correct.
The breeding and keeping of livestock happens elsewhere.
That's correct. The relevance of this paragraph in that it also includes the same occupation.
Yeah, occupied together with,
Yes.
yes.
And
And the result of the UT's conclusion is that those words in paragraph 3 bear a different meaning from their meaning in paragraph 5.
Yes, and it's with that in mind, I just wanted to take the court to the structure of paragraph 5, because within paragraph 5, 5(1)(a) is where a primary building, if I may call it that, a building that's actually used for housing livestock will be exempt. 5(1)(b) is applicable to buildings which are not primary livestock buildings but are ancillary, and in that situation, in order to be exempt, the building must satisfy two elements: the same occupation test, occupied together with, and a use element, in that instance a different use element, in that it must be used in connection with the operations carried on in that building or those buildings. And then subparagraphs 2 and 3 provide further restrictions in relation to those two categories of building. And when one reads paragraphs 5(2)(b) and 5(3)(b), any building which is claimed to be exempt as effectively an ancillary building has to satisfy that same occupation test. That is, it must show that it's occupied together with the land or the building, depending upon whether it's related to a primary livestock use or a dual agricultural use, which includes a livestock use as well as another agricultural use. And so I spend some time just taking the court to that, because in my submission one can see the function of the occupation test in relation to an ancillary building in restricting not only the exemption to buildings and land that are occupied by the same occupier, but where the building specifically is occupied together with the agricultural land. And where the occupation test is deployed in the legislation, in each case, it's deployed additional to the use test, showing that firstly those are separate tests, and secondly that each has its own role in ensuring that the exemption applies properly to the building.
But under paragraph 5, if you've got a building which is used for the keeping or breeding of livestock, and that's all it's used for, you get the exemption whether or not you occupy together with agricultural land.
Exactly so. That's a direct legislative provision which provides the exemption for the primary livestock building. If you were seeking an exemption in relation to the building in which the grain was kept to feed the animals, then you would have to show that the occupation test and the use test was met in relation to that grain building. And that's a distinction of some significance in my submission, because it applies where one is not dealing with the primary agricultural use, but the ancillary building which is subsidiary to and occupied together with that land or that building. My Lord, on page 37 of the bundle, the note 1 indicates that the present law is the result of the amendment that occurred as a result of the Local Government Act 2003, which featured centrally in the Tribunal's decision. That amendment is set out on page 49. And to be clear, as set out on page 49, subparagraph 2, previously the use element said used solely in connection with agricultural operations on the land, and that was changed at A to use solely in connection with agricultural operations on that or other agricultural land.
Yes.
And so the effect was that the use requirement did not require the building to be used solely in connection with agricultural operations on the agricultural land which the building was occupied together with. My submission is that the occupation and use elements are distinct tests, and that the use element is now neutral as to whether the agricultural operations are on that land, that is the land with which the building is occupied, or other agricultural land, or both.
Yeah.
The explanatory memorandum is also included in that tab. Page 71, the sidelined passage, paragraph 122, is addressing the change that was made to paragraph 3. And as the court will see, this change was made, it says in the second sentence, to reflect modern farming practices, so that where farmers work on other agricultural land, perhaps on a share or contract basis or through the pooling of resources or machinery, the exemption will apply. So if I may give an example on my case, if one had an arable farm which contained a barn that was used to store grain and machinery, as originally worded, that barn would be exempt if the barn was occupied together with the arable land and it was used solely in connection with agricultural operations on that agricultural land. If the machinery was also used to harvest other farms' arable land and to store their grain, then it would not be exempt. The effect of the amendment is that that farm is now exempt. And that indicates in my submission the centrality of the and between the occupation and the use element, in that both must be met. And it follows in my submission that a change in the one element, the use element, need not have any necessary implication for the meaning of the other.
Just looking at the use test for the moment, if let us assume the occupation occupied together with test is met. Let's assume that. I know you say it's not, but let's assume it is. The use test would be satisfied, would it not, if the buildings with which we are concerned were used in connection with the agricultural operations on the farms owned and occupied by the independent egg producers alone, without anything to do with Fridays.
Yes, subject to a judgment of fact, yes. And my lord, in my submission, that highlights, if I may say, the role that is conferred by the legislation on the occupied together with. And my lord, in my submission, the memorandum to which I've taken the call is entirely consistent with that. It's plainly relating to the use element, and it's plainly anticipating farmers being able to work other land in addition to their own, and vice versa.
Well, in addition to or instead of, perhaps.
Instead of under the use requirement. As I say, my lord, they would still have to satisfy the occupied together with test, which would, on my case, necessarily require there to be a functional connection between the land and the building in any event. And my lord, I don't make this as a facetious point, but if Parliament had wished to amend the occupation test, then it would have easily been capable of being addressed. The deliberate parliamentary choice was simply to deal with the use element, and my example in the memorandum in my submission provides a perfectly coherent explanation as to why that delivered a beneficial effect to the agricultural sector.
Yeah.
And my lord, if I may make this submission and then turn to the history of the legislation. The test has never been in relation to buildings, only about the use. Since buildings were brought into the legislation, it's been a requirement not only that they're used for agricultural purposes, but for buildings that are ancillary to agricultural land, the occupied together with test has at all times been a feature of the legislation. But what I have a brief canter through the legislative provisions prepared. I'm not sure if the court would find that of assistance. I would like just to indicate when the exemption in relation to agricultural buildings entered into the legislation.
Yes. Well, we have looked at the history of it all. It all starts with the Great Depression in the late 1880s, when British agriculture was on its knees.
Well, there are two things moving. One is, what is the exemption for agricultural land, which the court will have seen came down from half the standard rate to a quarter of the standard rate, and then to a zero agricultural rate, which was 1929. The other thing that was happening was the modification of the definitions of agricultural land and agricultural buildings. So if I may, just very briefly on page 3 of the bundle, the original exemption from 1896 only related to agricultural land. That remains the case through the 1923 Act at tab 2. At tab 3, the 1928 Act, this is when there was a specific reference to agricultural buildings. That's within section 2. Section 2, subsection 1, used the expression agricultural hereditament. That was then said to include agricultural land or agricultural buildings. And agricultural buildings is defined at the bottom of that page as meaning buildings occupied together with agricultural land or a market garden, and in either case used solely in connection with agricultural operations therein.
They're on, in fact.
They're on, forgive me.
That was later changed to that land before we get to the 2003 Act.
page 24, tab 5, the 1967 Act had the effect that by subsection 1, effectively it was a direction that no agricultural land should be rated or included in the list. So that was the way in which it was exempted from rating. And the definitions are then given in subsection 3. This is now much more similar to the structure of the 1988 Act, Schedule 5, in that subsection 3b, certain agricultural land is land by virtue of its relationship with a specific building. And in relation to the definition of agricultural buildings in subsection 4a is effectively the same approach to paragraph 3 of the 1988 Act. And my submission is that the legislation shows that when agricultural buildings were brought into the field of exemption, it was done by reference to their close connection with agricultural land. And that definition therefore ties the agricultural building very tightly to the occupation of the agricultural land together with which it is held, to ensure that that ancillary building benefits from the exemption. And that has been the legislative approach since 1928. It wasn't altered in 1988, and it wasn't altered in 2003. The 1971 Act, which is behind tab 6, for present purposes is notable mostly by reference to subsection 2, which, as I've said, was the response to the Herod case, and so provides the specific exemption in relation to livestock buildings. It echoes, it's similar in structure and language to paragraph 5, and at this time what is now paragraph 3 was unamended. It remained as it was in the 1967.
Yep.
My lord, we did include in the authorities bundle at tab 22 and the recent Supreme Court decision in For Women's Conduct. I don't propose to make any submissions as to the principles of statutory construction in this court. I know that they're very familiar. In terms of my fourth topic, case law, mindful of the invocation and the case concerned, this is tab 12 I would like to look at first, please, the Eastwood.
Yeah, I mean, Herod and Buxted are the principal cases.
Exactly so. They're the principal cases largely because each of them had the effect of arriving at a House of Lords interpretation of the relevant phrase that had been kicking about, if I may say, the Lands Tribunal and different views having been expressed. And in each case, since these cases were decided, neither of those phrases has been the subject of any appellate court consideration. They've been taken, as I think I say in my scope of argument, as effectively settled law. There's no dispute either, my lord, as to what this case says, or that
we're looking at Herod now, are we? Yeah.
Or that the principles were applicable to the case before the tribunal. If I may move quite quickly, hopefully, through this, page using the authorities bundle pagination, the leading speech is given by Lord Reid, which begins on page 153. At the bottom of that page at H, Lord Reid notes that rating law treats agricultural land and buildings separately. And at the top of page 154A, he takes what I submit has become the orthodox approach of considering the two elements of the exemption test separately. The sideline passage from 154D to H effectively sets out Lord Reid's interpretation of what that phrase means in context, the use solely in connection with. And Lord Reid highlights that the use must be subsidiary or ancillary to the agricultural operations on agricultural land, and at E emphasises by reference to his perceived purpose of the derating provision as being to benefit agriculturists rather than commercial enterprises. And so it's not enough if there's a substantial connection to agriculture. It must be, the use of the building must be ancillary to the operation on the land.
Yeah, this is looking at the use test, though, not the occupation test.
In my submissions, Herod is only relevant in relation to the use test. I'm setting this out now because of the second element of the grounds of appeal.
And he repeats that again at G on page 154, just above it.
Yes, thank you, my lady. My learned friend points out in his skeleton absolutely correctly that at H, Lord Reid says that no doubt this must be interpreted in a reasonably liberal manner. Lord Reid goes on then to make reference to a Scottish line of authority, and at B notes that a test developed in Scotland, which Lord Reid seems to find helpful, is whether this was really an independent enterprise or simply an incident of the system of farming the agricultural land. At 155E is a relevant section in that Lord Reid recognises that this is effectively a spectrum. There will be a range of activities as one moves from agricultural production to retail, and it's a question of where one draws the line. And in my submission, reading Lord Reid's speech, also the speeches of the other lords, the line is drawn when one moves beyond an activity that's no longer reasonably subsidiary or ancillary to the actual agricultural operations of producing the crop. And that is what Lord Reid says at E. And in my submission, this all comes back to the exemption being applicable to agricultural land and buildings. And so one asks, what is it that agricultural operations are doing? They are producing whether it's a crop or a product in the case of the livestock industry. So a building housing a commercial or an independent activity, albeit connected to agricultural operations, will not meet the test.
A butcher's shop.
Nor will a shop. A shop, my lady, is perhaps a more clear example of when one has crossed the line. The harder question is at what point does one cross the line? When one comes to, for example, centralised distribution centres. So where, for example, soft fruit may come from a number of farms in Kent to a centralised area, it already comes packaged to a degree, it's then repackaged, stamped for the supermarkets and sent out as a distribution exercise to the individual supermarkets. The question is, on what side of the line does that fall, and how does one adjudicate that question? And my submission is that the guidance is clear, that it's by reference to concepts of subsidiarity, ancillary, or as it's put by Lord Morris, whether it's, as he says, at 160 G to H, buildings that are needed as an adjunct or a necessary aid to agricultural operations taking place on agricultural land and used solely in connection with those operations. And the court has my emphasis that it's really focusing on the agricultural operations on the land, not one does with the product once it's been produced. I just draw attention to 155H just to complete the analysis of Lord Reed, that the court held that in that case the rearing of the livestock in the buildings was a separate commercial enterprise from that carried on the agricultural land. In reading the case, the court may have noted that a fair amount of the subsequent analysis from page 155 is really dealing with the need of the House of Lords to disagree with what had previously been the Court of Appeal leading authority of Thompson and Milk Marketing Board at, you'll see it, 156C, where Lord Reed and the other law lords concluded the Court of Appeal had applied the wrong test, in that they had been looking to see whether there was a combined agricultural operation, and that's set out at E.
Yeah.
And the House of Lords concluded that that case and others following it had misinterpreted the provision. The other reason, my lord, this case is relevant is that there is an observation overturn in the speech of Viscount Dillon at page 165.
Yeah, and that was picked up in the Buxted case.
It was picked up in the Buxted case. It was common ground, certainly by the time the case reached the House of Lords, but I think at all times through its history, that the occupation element was met by the poultry sheds in that case, and so the debate was only as to the use element. And it is at page 166 between E and F that Viscount Dillon notes some surprise as to that concession having been made, and says what he says at G. And it's those observations about the occupation element being an attempt to define a farm in statutory language that were then picked up in the Buxted case. I need say no more about them. I don't rely on that as providing any kind of test, but it does inform the history of the debate. If I may then turn to Hambleton and Buxted poultry, we've included both the Court of Appeal judgment and the House of Lords in the authorities bundle. Tab 14 is the Court of Appeal. The head note is fuller, provides perhaps a better background to the facts. I won't read it out. There were a number of farms and inheritance in play. The case concerned the exemption for a mill and a processing factory. The ratepayer claimed an exemption in relation to those buildings as agricultural buildings. The lead judgment was given by Lord Justice Glidewell. I may ask the court to look at page 181, please. At H, at the bottom, Lord Justice Glidewell begins with the orthodox treatment of the need to meet both of those elements. And then at the top of page 183, Lord Justice Glidewell indicates that he will deal with each of those elements in turn, which he then does, as indicated clearly by the inclusion in inverted commas of the occupied together with test. And in the Court of Appeal, but not the House of Lords, there was an argument as to the use element, but that did not make its way through to the higher court. As to the occupation test, Lord Justice Glidewell at 183E noted Viscount Dillon's obiter, which the court has seen. He then covered some Lands Tribunal cases, such as Hill's Hog, which had moved very firmly towards a functional means of satisfying the test rather than a physical or geographical means. At the bottom of page 184, Justice Glidewell says that they were referred to Scottish land valuation cases, but he doesn't find them of assistance. I just mentioned that there because the House of Lords do refer to those Scottish cases and find some assistance in them. At 184, the sidelined passage in effect, Lord Justice Glidewell agrees with the earlier cases that there must be a clear functional connection in terms of, as it's then put, men being sent out, workers being sent out from the building to the land. Lord Justice Glidewell's own interpretation of the phrase occupied together with is given on page 187 from D to G.
Yeah.
And no doubt the court has read that. It places particular emphasis on the need to give the word together meaning, in addition to just a building occupied with land. And the meaning that he gives to the cohesive phrase, including the word together, is then set out at G, and it requires a single occupier, but also that the activities carried on in both are jointly controlled or managed. Thirdly, that the physical communication between the two buildings is by reason either of physical nearness or some other factor so close and convenient that they can properly be regarded as being occupied as parts of the same enterprise. I therefore conclude that the tribunal erred in adopting the wrong test to decide which of the buildings was occupied together with.
So, I mean, this is a case, isn't it, like other cases where the question is, can you aggregate two or more hereditaments in order to produce the agricultural exemption for buildings?
My Lord, in my submission, this is not a case of aggregating two exemptions. The exemption will be, two hereditaments. The exemption will be claimed in respect of an individual building. It's then necessary first to identify the agricultural land that's in play and then reach a view as to whether or not the two tests are met in relation to that building. That may be within the same hereditament. So, for example, on the farm in question, there are some buildings which are used for the further preparation of egg products, for example, sandwich fillings, things like that, in buildings which are agreed not to be exempt. The question is one of within the same hereditament, potentially. It might be that an exemption is claimed across two hereditaments, but it's not a question, my Lord, of aggregating. It's a question of, given the conclusion as to the hereditament, is the individual building falling within the exemption, i.e., does it meet the occupation test and does it meet the use test? If it meets one but not the other, it will fall outside the term.
So it's of no great significance, is this your case in this appeal, that Chequer Tree Farm is a single hereditament because it's agreed that part of that hereditament does not benefit from the agricultural buildings exemption.
Lord, yes. The hereditament will always be a valuable tool of analysis in rating law. And when one comes to the physical unit, I accept it will be relevant.
Yeah.
But when it comes to the individual exemption, one is not determining that by reference to is it in the same hereditament. You need to overlay onto that the specific test for the specific exemption. And that will differ, as the court's seen, between whether it's a livestock farm or an arable farm or a beekeeping enterprise under paragraph 6. My lord, the reason the Court of Appeal judgment is set out, and I've spent some moments on it, is because that particular final element of Lord Justice Bridewell's judgment is disagreed with by the House of Lords.
Sorry, which bit? Is
The
disagreed
bit
with?
at G where it says, by reason of either a physical nearness or some other factor so close and convenient that they can properly be regarded
Oh, the same
as being
enterprise, yeah.
occupied as parts of the same enterprise.
Yeah, so that's when Lord Slynn goes for a single unit.
Lord, I would also, in turning to the House of Lords judgment, which is at tab 15, page 191, I would invite the court, if I may, to have regard to the submissions, the arguments that were made in that case by the respective parties, which are set out from pages 192 to 194. And I say that because each party recognises that there should be both a functional and geographical element to the occupation test. And each party recognises that one is dealing in occupation with a known concept in rating law. The real difference between the parties, and the court will see this, the ratepayers' submissions at the bottom of page 193 and the valuation officer's submissions at the bottom of page 194. The real difference between the parties was how strong does the functional connection have to be? And it was the valuation officer's submission formulated at 194H that ultimately the buildings needn't be contiguous, but through location, common ownership, common machinery, common workforce, they must, as a matter of fact, be, and in that case, obviously, they used the phrase one poultry farm.
Sorry, where are you?
194.
Oh, I see, H, yeah.
Lord has said, Lord Slynn gave the speech with which all the other members of the court agreed with. At page 197, the new paragraph just below F, Lord Slynn identified that the only question before the court was whether the factory can be said to have been occupied together with buildings used for the keeping or breeding of livestock, so as to satisfy the requirements of section 21B of the Act. It's plainly an exercise in statutory construction.
So the use point that was in play in the Court of Appeal had gone by then.
It had fallen away. Over the page at 198 D to E, Lord Slynn identifies the ultimate interpretation given by Lord Justice Glidewell, which we have just looked at. Page 199 is the reference by Appellant's obiter, which resurfaces. Page 200 at the top. This is the reference I mentioned earlier to the Scottish cases where Lord Slynn, this is the case of Middle Lothian Assessor and Buccleuch, which is included in the authorities bundle. Lord Slynn finds some assistance in the speech of Lord Kilbrandon, which he sets out at sea, which comes back to my Lord Justice Lewison's observation as to the hereditament, the notion of rating focusing on a unit rather than scattered units of property is relevant.
Yeah.
And at E,
So D to E, he agrees with Lord Justice Glidewell. Well, then F to G, he says
moves
something
further.
rather different.
Not enough to be part of the same enterprise, must be
One agricultural unit.
a single agricultural unit. The background to the case, of course, is geography really relevant? And it moves from there to saying when one brings together the rateable concept of occupation and the need for both functional connections and geographical connections, what one is looking for in order for the building to be occupied together with agricultural land is a single agricultural unit. And my lord, the test that Lord Slynn then uses to
Page 201E.
exactly say worked together. And I emphasise work together because that's plainly a functional consideration. So clearly the case, my lord, my lady, that's not sufficient to be part of the same enterprise, not sufficient to be in agricultural use, has to have sufficient togetherness, physically and functionally, to be a single agricultural unit. My lord, my submission, as is plain from my skeleton argument, is that remains an applicable test because it is a statutory interpretation of the same phrase in the same context, seeking to achieve the same purpose, and it's not affected by a change to what has always been a distinct but additional requirement for use in a particular way.
And that's the critical question, because the UT said it had. So that's where we are in 2003.
Absolutely
Settled law.
settled law.
Question is, did the 2003 amendment change it?
Yeah, and I think I've made my submission. No, I will come back to that in the context of what the tribunal said about it.
Right.
But if I may just complete the cases by reference to Woolway. And that is a case I know my lord's very familiar
What
with.
are we going to get out of Woolway? That's telling us what a hereditament is, but we have a single hereditament here, we know that. Part of it's exempt, part of it's not, we know that too. So what are we actually going to get out of Woolway?
In my submission, not much more. I was going to refer to it to make the point that one is, these days, post-Woolway, largely dealing in identifying a hereditament with a physical exercise.
Yeah.
And this test, as I indicated earlier, is overlaid on that concept of hereditament.
And Lord Sumption explains that and says it principally applies to derating cases, which this is one.
That's all I was going to say.
And he also makes the point that business rates were tax on land, not businesses.
Or I don't need to go to it in that case. If I may then put the authorities bundle to one side and take up the core bundle, the replacement bundle. I say replacement only because it contains the replacement skeleton arguments.
Yes.
And my lord, you indicated you'd read the decision as I had expected. Just to note in passing, the law is set out in paragraph 12.
What are we looking at? The UT?
The UT decision, forgive me, tab 5 from page 65.
Yeah.
The law is set out in paragraph 12. Just to note in passing, you may have seen as a reference to an earlier tribunal case.
Yes.
We haven't included that in the bundle. In that case, as the tribunal said, it was the same members of the tribunal as it happened. They had taken the view that Buxted still applied, and it's not in the bundle because I don't take any point on that. They gave reasons for departing from that view, and that's the position that we now challenge. The tribunal's essential reasoning is set out by 3 discussion points. On page 76 of the bundle, discussion point 1 is whether farmer is still authoritative as to the meaning of the occupied together with phrase. They concluded that it was not. And paragraph 48 on page 77 provides the tribunal's alternative interpretation. And they say that second line, that the test can no longer require a functional connection. That's an important conclusion in my submission. They also say that it cannot imply that the land and the building have to be a single agricultural unit. Again, another important conclusion given what we've seen from Buxted. And thirdly, the final sentence, the tribunal seeks to give meaning to the word together, and they say it's likely to have a meaning beyond occupation by the same person at the same time, and they take it to mean that the building and land must be occupied as part of the same enterprise and must be geographically close and not contiguous. And I emphasise part of the same enterprise because the court will recall that was the language of Lord Justice Glidewell, with which Lord Slynn disagreed. So although they considered themselves not bound by Buxted, in many respects the tribunal's interpretation is a very significant departure from Buxted, in that it finds that there's no need for any functional connection whatsoever.
Do they explain why they got to that conclusion?
My lord, yes, it's primarily paragraph 42.
42.
And this is a point I'd like to come back to. But the reason they give, and amongst, yes, 42, and I should say within 48 as well, they say that occupation and use have been split up by the amendment. Now, in relation, I'll just take those 2 points head on, if I may. Now, firstly, in relation to occupation and use having been split up by the amendment, my lord, in my submission, that's wrong. Occupation and use have been distinct tests since 1928. And the 2003 amendment didn't change the structure of the exemption. It said nothing as to the occupation element. And that is also largely the answer to why paragraph 42 is in error. Because in my submission, what happens to the construction of the use element doesn't carry any necessary implication for the construction of the occupation element. But if I may just return to, so paragraph 48 is the interpretation given by the tribunal, which the Valuation Office challenges on this appeal and says is wrong. Paragraph 51 of the decision on page 77, discussion point 2, the conclusion was that the buildings were exempt
Yeah.
on that application.
Yeah.
And that is a point that we challenge on this appeal, because if the test is wrong, then that conclusion can't stand. Discussion point 3 from paragraph 52 then seeks to apply Buxted in the alternative. In considering this question, the tribunal sought to assess the building's relationship first to Chequer Tree Farm, and at paragraph 55 concluded that the egg packing centre isn't occupied together with the agricultural land at Chequer Tree Farm, because, as they say, the tribunal says in the centre of that paragraph, they were functionally independent. The Chequer Tree Farm grows crops.
Yeah.
And at 56, they say that the operations and management weren't connected with each other. That's all about Chequer Tree Farm. They then move to consider from 57 to 59 whether the egg packing centre at Chequer Tree Farm was occupied together with the other 4 farms in Kent that are owned and occupied by Fridays. And they concluded at 59 that the Fridays farms are, place some emphasis on this, operated as a single agricultural unit. It's a phrase I'll come back to. But they concluded that the egg packing centre was occupied together with, and the exemption would therefore arise. And that is therefore a conclusion that is challenged on this appeal. And over the page, there was then a fairly succinct consideration of the use element, which concluded at paragraph 63 that the use element was met, and that forms our final point of challenge on the decision. So, my lord, my lady, if I may turn to my submissions. I set out within the core bundle at page 29 at paragraph 49 some points of approach, which I won't read out, but they form my introduction to the submissions, because this is, of course, an exercise in statutory interpretation. In terms of the occupation element, there are, in my submission, 5 reasons why the tribunal's interpretation is wrong in law. Firstly, the tribunal is wrong as a matter of statutory construction. I've largely developed those submissions, but the statutory purpose remains the same in relation to the occupation element, the wording remains the same, and Lord Slin's interpretation remains correct as a matter of statutory construction, giving meaning to every word used in its context. And all of those components are then brought together in a workable test as to whether or not the 2 or more buildings and agricultural land are worked together to form, in a real sense, a single agricultural unit. The second reason I say it's wrong in law as a point of interpretation is because Parliament had left in 2003 the occupation test, the subject of House of Lords authority, unaltered. And this strongly suggests that Parliament intended the words to be given the same meaning. The third reason, and in my submission, the central error in the reasoning of the tribunal, is that the 2003 amendment carries no necessary implication to depart at all, but certainly not radically from the settled meaning of the phrase. And there are three sub-points to support that submission. Firstly, the occupation test remains entirely workable as it was set alongside the new use requirement. And my lord, my lady, to illustrate that point, within the tribunal's decision at page 76 within the core bundle, the tribunal gives an example which is very similar to the example I gave earlier of where one has a barn on an arable farm being used to store machinery and equipment, and it is used both on the farmer's land and other land. Before the amendment, that fell outside the exemption. With the amendment, it falls inside it. So there's no inherent difficulty in keeping the occupation element the same and setting it alongside the new, wider use test. Nor can it be said that keeping the occupation test renders the amendment pointless, because that example also demonstrates that buildings will fall within the exemption that otherwise wouldn't, and the buildings that will are a reflection of modern farming practices, including sharing of equipment, pooling of resources, as alluded to in the explanatory memorandum.
I'm not sure that I entirely understand the hypothetical facts which the Upper Tribunal are proposing in their paragraph. Are they suggesting that the machine shed is occupied by Farmer A? Farmer A also occupies adjacent agricultural land which makes no use of this machine shed at all, and the machine is used only on other agricultural land. That's the factual scenario they're positing, is it?
That's the factual scenario they're dealing with in paragraph 44.
Yeah.
The example I was momentarily ago dealing with was 43.
Right. Yes, well I don't think you would quarrel much.
No,
with that, would you?
not only do I not quarrel, I say that's exactly the situation that the amendment captures.
Yes.
Because the combine harvester is being used on other people's land as well, because it's
Yes.
a very expensive piece of equipment,
Yeah.
and it's shared.
Yeah.
That
so
is now.
So it's 44 that you
44
attack.
is yes, because that's very similar to the facts of this
Yeah.
case, and no doubt that's why the tribunal pose it as a test. And in my submission, there are difficulties with the example in that it anticipates there being occupation of the shed by the farmer, even though it's positing that farmer making no use of the equipment within it. And that is a contrived example in my submission, because one would have to consider quite carefully whether or not the farmer did indeed have occupation of that shed. But at this point in my submissions, my lord, I'm not criticising paragraph 44 so much as saying that it's the tribunal's approach is to say that the occupation element must have changed because the use element has changed. And in my submission, that's just not correct.
Yeah.
The paragraph 43 example is a good indication of the beneficial and meaningful effect of the amendment and how it can sit entirely alongside the occupation element. The barn, in order to be exempt, no problem with the barn being used to farm other people's land under the use element, but the farmer must still show that the barn's occupied together with his farm. The second sub-point in support of why there's no need to depart from the established meaning is that, I won't go back to these, but when one looks at the explanatory memorandum, and also there were references in the Tribunal's decision at paragraph 37 to statements in Parliament by Nick Rainsford MP, those documents, which are secondary sources of material in terms of statutory interpretation, but even so, those are entirely consistent with the submission I've made. They all or both refer to providing a benefit to a farmer who is using his equipment on a wider basis across other farms. And I have no difficulty with that whatsoever. It relates entirely to the use element. And
While we're on the subject of parliamentary statements, what are we to get out of Mr. Chamberlain?
Forgive me, my lord,
We've got an extract from Neville Chamberlain in the bundle of authorities, and I have no idea why.
my lord, I understand.
I might have to take responsibility for that.
Was it supposed to be Nick Rainsford?
My lord, no, it wasn't. Nick Rainsford isn't in the bundle.
Right.
You have.
No, we've got it quoted in the
You
decision.
have all about it in 37. My understanding, well, correct me if I'm wrong, the Mr. Chamberlain statement is to make clear, which I accept, that it was intended in the 1928 Act to bring agricultural buildings within the purview of the exemption.
Yes,
I think
right.
Mr. Ormonroy might say something more about that in his submissions. But
Right, well, that's fine. We'll wait and hear what he says. Now, you had a third sub-point.
my lord, yes, and this is the point for the note, my skeleton paragraph 64, and it relates to the tribunal's paragraph 42, that the tribunal wrongly, in my submission, set up the occupation element and the use element as mirror images of each other. And it's only when one does that that one starts to think, well, if the use element is changed, then the occupation element must too.
Yes.
Sorry, my. Sorry, forgive me, my gown appears to have got stuck in the bench. Apologies. Yeah, so, my lord, that was my submission, and it was the point I effectively made orally earlier that 42 sets up a false question for itself, and that is also indicated in paragraph 48 that the tribunal appears to have seen the amendment as having the effect of splitting up use and occupation for the first time, when in my submission that's not correct.
So that brings us to your fourth reason.
Oh, it does, and that is the fourth submission is that the tribunal's judgment or interpretation omits any functional connection at all between the land and buildings. And if that's done, it widens the exemption beyond agricultural buildings. And my lord, it's in the context of that submission that I wish to make some observations on the example that's given at paragraph 44. Because the example given at paragraph 44 seems to envisage a building on a farm which is not being used by the farmer at all, and yet meets the occupation test simply because it's in the same occupation as the agricultural land and is next to a field. As an interpretation of occupied together with agricultural land, you have my submissions. That's plainly my submission, not giving the words their meaning. But in terms of its consequences, it means that a warehouse on a farm could be used for not for a primary agricultural purpose. And it would only then be controlled by its use by reference to the use element, which requires only that the building is used in connection with agricultural operations. And so this is potentially a widening of the exemption beyond the building actually being an agricultural building.
I think you'll have to explain that a bit more detail because I haven't quite grasped that point.
Well, if I may, if I
Take your warehouse example, you're positing what?
if there's a warehouse and it's nominally occupied by Farm A Limited.
Yeah.
And it's used to run a commercial machine leasing business. And none of that machinery is used on Farm A. There is no functional connection with Farm A. It's just that the farming company is using its building to commercial terms lend out machinery to other farms. That may well meet the use test if the machinery is being used in connection with agricultural operations. And on the tribunal's approach, it would, paragraph 44, it would meet the occupation test. And in my submission, that is then a losing of control over the exemption, such that in effect a non-agricultural building, a building that's occupied for a commercial purpose, is then benefiting from the exemption. Sorry if I wasn't more clear. The fifth reason why the tribunal is wrong the tribunal itself alludes to this at paragraph 49 on page 77, is that as a result of the tribunal's interpretation, the same phrase, occupied together with, has not only a different meaning, but a very different meaning, as between paragraphs 3 and 5. And my lord, my submissions earlier as to the structure of the legislation, paragraph 5 is not only dealing with primary livestock buildings, it is also dealing with the ancillary buildings to those. And in my submission, there's no reason why there should be such a different test, for example, for a building that stores grain in relation to a livestock building, and a building that stores grain in relation to a arable fish. So, my lord, those are my 5 submissions as to why the tribunal was wrong and why I would ask the court in my submission to revert to Lord Slim's interpretation. I have to deal obviously with the consequences of that submission for the decision. Given that on page 77 of paragraph 51, it's clear that if my submission is right, that conclusion must fall, because it would then be the application of the wrong legal test. In relation to the conclusion at paragraphs 57 to 59, this is at the top of, at the bottom of page 77. The tribunal is reminding itself of Lord Slin's speech.
Yes.
And what they say at the top of page 78 is, from that we can conclude that being an agricultural unit must be something to do with management. The problem was that the 48 farms were each run separately rather than being a unit with one or more others. Now, my lord, that is not an accurate summary of Lord Slim's speech, which gave the test of being worked together as a single agricultural unit. It contains a clear focus on management. And also, the point of Lord Slim's judgment wasn't about the 48 poultry farm. It was about the provender mill and the processing factory. And then, when it comes to 55 and 56, the tribunal accepts that the buildings, the egg packing centre, isn't occupied together with the Chequer Tree Farm, which is of course the hereditament in which it sits. That's clearly not the case because it's functionally independent. And then the analysis in 58 and 59, 58 is entirely focused on what's necessary to sell eggs. And the same point is made by reference to the 1.4 million eggs that come from the farms across the country, as well as the 1.7 million eggs a week that come from the Fridays farms. That, as Lord Lewison indicated earlier, that's a functional connection. That's a functional connection that's the same wherever the eggs come from. And paragraph 59.
Well, that's true, but at this stage, the Upper Tribunal is in effect asking itself, are the processes which are, the operations which are carried on these buildings really reasonably necessary to be able to sell the eggs produced on Friday's farms? And it's perfectly true, as you say, they're looking at the other egg producers as well. But within the Herod approval of the Midlothian case, why are the Upper Tribunal not entitled to say this is sufficiently connected with the agricultural operations on Friday's other farms as to satisfy the single agricultural unit test?
My Lord, the tribunal deal with the Herod point somewhat later in this decision. At 58 and 59, this is the tribunal's application of Farmer and Buxton. This is their application of whether the egg packing centre and the Kent farms are worked together as a single agricultural unit.
Why doesn't the reasonably necessary to prepare the crop for sale come into that consideration?
It may do. Yes, I accept it. It may do, and of course, a functional connection is necessary to meet the occupied together with test. But my submission is that what the tribunal here do is to identify a functional element which appears more to do with making ready for sale, which is the same across the close farms and the remote farms.
Yeah.
But what the tribunal then fails to do is to go on and consider whether the land at the 4 Kent farms is occupied together with the egg packing centre at Chequer Tree Farm so as to form a single agricultural unit. And having identified at the top of the page that the case, the speech of Lord Slynn was really something to do with management, at paragraph 59, the tribunal expresses its view accordingly. So based upon the functional connection in paragraph 58, the Fridays farms are operated as a single agricultural unit with the 3 buildings and vice versa. So my submission is that the tribunal has, perhaps influenced by its earlier interpretation of the need for it to be a joint enterprise, failed to apply properly Lord Slynn's question, Lord Slynn's text.
Can we just go back to 57? They're asking themselves, are they occupied together with the Fridays farm in the sense of being worked as a single agricultural unit? So they've posed the right question, have they not?
The right headline question, my Lord, yes.
Headline. And then they go on to ownership and occupation, not contiguous, they're near each other, they were part of the same business enterprise. So thus far they've applied the Glidewell test, if I can call it that.
Exactly so.
But they go on in the next sentence to ask, were they sufficiently functionally close to be described as a single unit? Now that's going to the Slin test, isn't it?
It is without question going to the Slin test. But my lord,
So
my-
they've asked themselves the right question, and they answer it, don't they, at 59?
my lord, my submission, as my lord indicated, in referring to the test in 57, if one reads together 54, 57, 59, trying to read it fairly across the page, 54 says it's got something to do with management. 57 then says they're part of the same business enterprise of producing eggs. And then at 59, it refers to being operated as a single agricultural unit. And my submission is that this has carried across a watered down version of the Lord Slin test, such that they do not ask themselves whether and this is about agricultural land, whether the agricultural land which should be identified, which is no doubt the ranging land of those 4 farms, is that agricultural land worked together with the egg packing centre, which forms part of the separate unit, the
So-
separate hereditament.
The question is, are the Fridays farms worked together with these buildings as a single unit?
Is the
Single
agricultural
agricultural
land,
unit.
is the agricultural land at the Fridays farm worked together with the egg packing centre at Chequer Tree Farm as a single agricultural unit, bearing in mind the role and relevance of hereditament and units of occupation to that question?
Yes.
My lord, the 7th topic I wish to address the court upon.
Sorry to be slow, can I just ask you this? So, I understand that submission. If that was wrong, then the Upper Tribunal's alternative approach would stand.
My lord, yes, and the valuation officer would be grateful for the judgment on the first issue nonetheless.
Oh, I'm sure about that. I'm just
As I
slotting it all together.
absolutely right.
Yeah.
In order to overturn the exemption, my submissions on both of those points have to be.
Yes.
Yeah.
Certainly.
Sorry to be slow. Thank you.
Okay, thank you very much. The 7th topic is my learned friend through Respondent's notice seeks to uphold the Tribunal's decision on another ground. And we agreed for timetabling issues that I would make my submissions on that first rather than require my learned friend to reserve a right to reply.
Yeah.
So if it's convenient, I'll address
Yes.
that. The point is made at my learned friend's skeleton argument, which is page 55 of the page 55 of the
55, yeah.
core bundle. From paragraph 72. And it's unashamedly a new argument. It's not a point that was put to the tribunal or determined by the tribunal. It may have involved the tribunal considering some different issues, for example, more explicitly, the scope of the hereditaments in question. But nonetheless, as I say, the valuation officer seeks to have a full consideration of the issue. We don't seek to close it down for any reason of not having been raised before the tribunal. The particular argument at paragraph 73 is that the occupied together with Tess, as construed in Farmer and Buxted Poultry, so as an application of Farmer, is satisfied as long as the buildings and agricultural land form part of the same heritage. But to an extent, I covered this in earlier submissions, but succinctly, the valuation officer accepts that the consideration of the hereditament is relevant to the question of occupied together with, but it doesn't go far enough to reflect the statutory language of occupied together with. And so it should not be substituted for a specific functional test between the land and the buildings as set out in Lord Slin's speech. My Lord Manelli, as you've seen, the tribunal in this case found at paragraphs 55 and 56 that the egg packing centre was functionally independent of the agricultural land at the Fridays farms. And any alternative test that doesn't require a material functional connection between the land and buildings is, in my submission, not a proper statutory interpretation of the words used. And in practice, as no doubt the court's aware, particularly concept with farms, many hereditaments will be identified by reference to their physical characteristics, their geography, without a detailed consideration of function within the hereditament. And so a building may well and rightly be included in a hereditament without having a direct agricultural function, and that building may be used for a range of purposes: storage, distribution, transportation.
Would the farmhouse be generally included in the same hereditament as the farm?
It may, I understand it may well be. It wouldn't benefit from the
No, because
exemption.
it's a dwelling, but it could be part of the
That's
same
an example.
hereditament.
That's an example of
Yeah.
the exemption applying in a partial way across the whole hereditament. And so in practice, what the ratepayer's submission amounts to is a reversal of the statutory burden to benefit from the exemption. In practice, it would have the effect that all of the buildings in the hereditament are exempt, unless the valuation officer is able to show that the building is used for a wholly different purpose. And in my submission, that presumption that a building on an agricultural hereditament is exempt is a direct reversal of the statutory framework and the policy of the Act, which requires a very specific test to be met before a particular building on a farm benefits from the exemption. Well, that's all I intend to say about it.
Yeah.
So the eighth topic, and my submissions that relate to the use element. And this reflects the discussion earlier in relation to Herod and necessary adjunct ancillary subsidiary, and the requirement that the use not be separate or independent from the agricultural activity. And in order to assess this, it's necessary first to identify the agricultural land in question. And I note that a facility for packing products for retail use is something that's very prone to fall in other circumstances as part of a retail use rather than agricultural use. So it's very much a question of properly identifying the test to ensure what buildings fall on the right side for the agricultural exemption. And so in that context, in my submission, it was essential that the tribunal reach a view and applies its mind to that subsidiary question. And I say it was essential against the facts in this case, which are that the packing centre is packing 3.1 million eggs, and 1.4 million of them, this is per week, 1.4 million of them come from farms across the country. They're centralised, and from that centralised facility, they're then sent out directly to the supermarkets to go on the shelves. In the tribunal's decision, at paragraph 62, 2, this is behind tab 5 at page 79. I accept entirely that the tribunal identifies the valuation officer's submission that sought to argue both the independent element, i.e. it's a primary use, and the subsidiary ancillary question as being not consequential to the agricultural operation of producing the eggs. I also recognise that ultimately it's a judgment for the tribunal, but my submission nonetheless is that when one reads 63, paragraph 63, which is the entirety of the reasoning on the point, no consideration is given to those concepts of subsidiarity or a potential dual use. The only reasoning that's given relate to what's necessary to make the eggs ready for sale. And that was never in dispute. What was in dispute is whether that process of making that volume of eggs from those various sources ready for sale in a centralised way went beyond the proper concept of being subsidiary to the agricultural operations on the land, bearing in mind that the 1.4 million eggs are transported to the facility stamped and on pallets. The case that the valuation officer was asking the tribunal to resolve was, it may be functionally necessary, but is it an adjunct? Does it go beyond what's ancillary? Is it an independent operation? Is this in planning terms a dual use? And the only answer that's given is that there is a clear functional connection because it's necessary for sale. I entirely recognise that the court will be inclined to a favourable reading of the decision. I recognise that the submissions that I made on behalf of the valuation officer are correctly summarised at paragraph 62. My submission is that those points weren't dealt with, and so Herod was not properly applied. The implication is that the tribunal misdirected itself as to the meaning of Herod. My lord, those are all the submissions I wish to make, unless I
You're
can
well ahead of time, Mr. Williams. Thank you.
say it was an outer limit. I'm grateful for the indications.
Yes, Mr. Ormondroyd.
Indeed, my lord, thank you. If I just briefly set out my stall before addressing the matters in the order set out in my skeleton argument. On the occupation requirement, I do defend the Upper Tribunal's primary approach to the law as sound. If that is wrong, I rely on the Upper Tribunal's application of Farmer to the facts as it saw them and experienced them on site and found them to be. The combined effect of those arguments, those two arguments, may reflect what the Upper Tribunal meant when it said in granting permission to appeal that the correctness of the decision was not in doubt, because although it recognised there was potential for argument either way on the law, it effectively found there was both ways on the facts. So that may be what it meant in those remarks. Because on either view of the law, it had concluded that we should succeed. I also make, as my other friend has identified, a further argument in support of the Upper Tribunal's decision, because if there is a criticism of the Upper Tribunal's favoured approach to the law, it is that it leaves the occupied together with test having a different meaning in two different paragraphs of Schedule 5. one may simply say, well, that reflects the very piecemeal and unsatisfactory way that Schedule 5 is drafted. But I appreciate that is a problem that has to be dealt with. Also, incidentally, the Upper Tribunal's decision on either basis leaves somewhat unresolved the ambiguity as to what exactly an agricultural unit is, because all we know from farmer is that it is not a farm. So although there is this concept articulated, what exactly it is supposed to relate to is a matter of some obscurity. My further argument proposes a degree of alignment between the unit of assessment and unit of occupation.
This is your respondent's notice point.
Indeed, yes. It proposes a degree of alignment between those units, the unit of occupation, the unit of assessment, and the agricultural unit as it is referred to in farmer, such that if, as is accepted to be the case here, buildings form part of the same unit of occupation, unit of assessment with agricultural land, they also form part of the same agricultural unit as well.
But the single agricultural unit test, whatever it means, is capable of aggregating hereditaments.
It may, yes. My argument leaves open the prospect that it could go beyond one hereditament, but my argument is just that where you do have a single hereditament, that very clearly satisfies the test. And it would be for another case where...
Well, that's, I mean, that gives effect to occupied with, but there's stress certainly in the Court of Appeals, occupied together with. And the whole of Lord Justice Glidewell's reasoning said, well, together must add something.
Yes.
And if you are occupying a hereditament, you are certainly occupying the entirety of the hereditament, but
yes,
you've got to give some meaning to the word together.
Well, I think it would give meaning to that, because the occupied with would apply to any parcels of land in the same occupation. Hereditament goes well beyond that.
Well, yes, because you've got to have a cartographic unity and so forth.
Exactly. So it's quite a restrictive test, actually. But anyway, I'll come on to that. But finally, then, on the use requirement, in my submission, there's little to see here. All that's happening is the appellant challenging the application of a settled legal test by a specialist tribunal, which correctly directs itself on the law and had the benefit of a site visit. So, in my submission, little in that last point.
Yeah.
I will just briefly touch on the factual background and the legal framework before responding in turn to my friend's submissions. Very, very briefly on the factual background, just three key points to draw out from that. The first is that the free range and organic egg production under consideration in this case is a land-based farming system.
Yeah.
And paragraph 7 in the decision on page 67 refers to the requirement for a lot of land, specifically 32 hectares of ranging land per 64,000 birds. And 32 hectares is, of course, 320,000 square metres. The unchallenged evidence before the Upper Tribunal was that the shed required to house that number of birds was 260 metres by 20.5 metres. So just over 5,000 square metres, or about 1.5% of the land area. So that gives you an impression of the size of the sheds that the birds roosted and laid in.
The Upper Tribunal doesn't, so far as I can see, make what I might call solid findings of fact about the independent egg producers, but there's no suggestion that their methods are any different from Friday's, because when they come to the question of use, long way further down in the decision, they recite your argument in paragraph 61 about operation on the Friday's farm and the independent farms, but they don't make positive findings. They are reciting your argument, which they accept, and I've inferred that they would have made those findings had they been asked to do so.
Indeed, I mean, my submission on that is that, I mean, certainly there was no controversy before the Upper Tribunal on that point as to there being any difference between the farming methods there, and indeed there was evidence that those farms were bound by a code of practice to effectively produce in the same way as Friday's did. And certainly if you look at paragraph 58 in the decision, it very much treats the two as equivalent. So that is, I would respectfully endorse that.
And the same approach is adopted at paragraph 11. It just is saying that there are 15 smaller independent farms who don't produce eggs on a big enough scale to do the packing themselves. But there's no other reference to any other method.
No, indeed. So that was the first point on the facts. Secondly, that land-based system is operated on Friday's farms that manage centrally from Chequer Tree Farm. And before the Valuation Tribunal for England, there had been a misleading impression given that each of the Friday's farms was, as it were, managed separately. That was corrected by the evidence before the Upper Tribunal, hence its findings at paragraph 9 in the decision, page 68, where it sets out the evidence on that and it effectively accepts that evidence. And thirdly, is that the operations in the disputed buildings represent what's necessary to bring those eggs to the relevant wholesale market. And my own friend said just now that as far as he's concerned, that is not controversial. So the Upper Tribunal directly found, again at paragraph 58, that they need to be graded before they can be sold, and it also follows that insofar as they're being sold to supermarkets, they need to be packed into boxes as well.
So what is the stamping that goes on at the producing farm? What's that? That's a lion stamp, is it?
It's a stamp which reflects the unit where they've been produced.
But it has the name of the farm on it, or what?
There's a number.
It's a number. Yes, it's just a number. And you'll see if you examine your breakfast eggs, as I have now become wont to do after becoming a this day. There is a stamp there, and part of that refers to the stamp from the producer, and part refers to the packing centre.
Right.
So as far as the legal framework is concerned, I'd set out at paragraph 17 to 32 the story of the development of the categories of exemption. Which,
give me those paragraphs.
17 to 32, the skeleton. Which sets out the story, which was accepted in its essential parts by the Upper Tribunal decision at paragraph 17 to 28. But I just want to touch on a few highlights of that story, given the importance of it. And the first point to touch on is the 1928 Act, which I come to at paragraphs 18 and 19 in the skeleton, and we find that on page 21 in the authorities from the land fund.
There's no dispute about any of this history,
Um,
don't think.
I don't. I think there is. Well, there may be one. There may be one point which is controversial about the width of the 1928 Act.
Right.
It may be that the controversy that there was about that has dropped away. Because it was this Act which first introduced reference to buildings, but also which first introduced reference to poultry farming in the definition of agricultural land. So we see on page 21, land exceeding 1/4 of an acre used for the purpose of poultry farming.
Yeah.
And that's the first mention. And this is what the Hansard material
Yeah.
for Neville Chamberlain.
If you keep a few hens in your back garden, it's not good enough.
Well, that's the 1/4 of an acre point.
Yeah.
That's why that was in there.
Yeah.
And I put the Hansard material in to make good the submission to that effect in the skeleton. But if we go to page 253, we have the Hansard.
253.
253.
Yeah.
The tab is tab 80. So in the second reading of the bill,
I
Neville
can't at the
Chamberlain-
moment see how this satisfies any of the conditions in Pepper and Hard.
Your Lordship takes that view, then Your Lordship will, of course.
It's not a pronouncement by a sponsoring minister on the meaning of a provision. He says he's going to look at an amendment, and bring it forward.
and that's what the poultry
Yeah.
farming does. But the specific point about it is the need which it is said to address is in relation to egg producers. So the point that I was making, and which this makes good insofar as that is controversial or disputed, is that firmly in Parliament's mind, when enacting the 28 Act, was free-range egg farming of the sort considered in this in this case, because it had been suggested at some points in the litigation that the sheds on the Fridays farms would only be exempt as livestock buildings under what is now paragraph 5. And my point is simply, no, they are, and always would have been, exempt as buildings ancillary to the use of the ranging land for the free range hens. So that is the point from the 1928. The other point on the wording of that in terms of the definition of agricultural building, and again this was controversial, but given what my own friend has just said to your Lordship this morning, no longer is that it is in terms of the link between the occupation requirement and the use requirement, both referring to the same land, and that was a consistent feature of the statutory scheme until 2003.
Yeah, that was the effect of thereon and that land
Indeed.
in the successive iterations of the statutory language.
Indeed. And that is the link which, in my submission, the Upper Tribunal was correct to say was broken in 2003. The next step in the development of the legislation was a broadening in response to the Farmers Machinery Syndicate case, which I don't need to go to, but we have in the bundle at paragraph tab 10, which related to a grain dryer owned by a syndicate of farmers, which was described as a novelty in this country by the Court of Appeal and found not to be exempt. The court suggested that if that were to become exempt, legislation would be needed. That duly followed in the 1967 Act, making specific provision for syndicates, and that specific exemption now forms part of Schedule 5 in its current form. Those amendments were facilitating farmers in making the changes necessary to accommodate modern and more capital-intensive methods of farming by allowing them one means of sharing the use of machinery. And in my submission, the 2003 amendments were a further step along the same road. So when we come to looking at Schedule 5 as a whole, that principle and that direction of travel is one that is of long standing. I will just touch finally, before turning to my own friends' submissions, on questions of approach to interpretation. And at 33 to 36 in the skeleton, I've sought to derive 4 general principles. Firstly, which I'll leave to my own friends say whether they're controversial or not, but firstly that the exemption is not to be construed restrictively just because it's an exemption, but on the ordinary principles of statutory construction. Secondly, to misquote both Jane Austen and Lord Walker of Gestingthorpe, it is a truth universally acknowledged that a statute must be construed as a whole. Thirdly, and specifically where text has been amended, the amended text should be construed as it stands as a whole. And I refer there to Bunyan on statutory interpretation, and the general principle that the usual intention is to produce a text that can be construed as a whole in its revised form. So one doesn't necessarily assume that certain words in the amended provision will have the same meaning as they had in the unamended provision. One looks at the amended provision as a whole. And fourthly, construction as a whole means giving each part effect in a way that does not frustrate the operation of the other parts. And in my submission, that is, the Upper Tribunal's approach achieves that objective, but my friends does not.
Would you factor into your approach to interpretation what is commonly called the Barras principle, that where a statutory provision has been authoritatively interpreted, particularly by the House of Lords, and it is reenacted in the same terms, Parliament can be assumed, absent any other indication, to have endorsed the interpretation put upon it by the highest court?
Indeed, and that would apply to the provision construed by the House of Lords, which was
Occupied together with.
Well, no, the actual construction provision it construed was the one in which was then in section 2(1)(b) of the 1971 Act. So it's the livestock, it's buildings ancillary to livestock buildings. So that's the provision which has been reenacted in similar terms and remains in similar terms. What one might call the primary definition of an agricultural building is now in different terms to the provision construed in Farmer. And that's the point I make about construing that amended provision as a whole, rather than, as it were, assuming that certain subset of words within it will have the same meaning as was said in Farmer. And perhaps in that context, I'll turn to Farmer, because although there is terms of the authorities, because although, as I say, in responding to my own friend, paragraphs 44 and 45 of my skeleton, Lewison has made some, as it were, purely linguistic criticism of the Upper Tribunal's decision. In my submission, there is nothing objectionable about it on that basis. It gives the Upper Tribunal's construction gives a meaning to each of the words in the definition, including the word together. And so there's no linguistic problem with it. The real challenge is not about approaching those words afresh. It's about saying that the Upper Tribunal and indeed this court are trammelled as to what it can conclude about the meaning of those words by the decision of the House of Lords in Farmer. And in my submission, that basic approach is wrong for the reasons the Upper Tribunal advanced. And let me make that submission good by reference first to Eastwood and then to Farmer. And Eastwood, if we just go to that in the Bunyan, please, page 146 to 147 is the headnote which sets out the facts. And the main problem for WJ&B Eastwood Limited appears at page 146 H in the headnote, in that they had 72 broiler houses. So this was not what I have described as a land-based farming system at all. The broiler chickens essentially never left the buildings. The system was described perhaps pejoratively by Lord Guest as factory farming. So that was the primary problem in that case. Lord Reed's leading judgment starts on page 153, and we see the provision being construed there was the original one from the 1928 Act with the linked occupation and use requirements. Over the page 154A, he identifies that link when he says, it appears to me to be obvious, just above B actually, it appears to me to be obvious that thereon means on the agricultural land together with which the building is occupied. And he goes on to note, and this holds good today, it does not matter whether the uses which are made of the buildings are in themselves agricultural operations. And I stress that because at various points in his submissions, Llewellyn Friend refers to the need for these to be agricultural buildings. He said, does it have an agricultural use or a commercial use? And refers at various points to this supposed requirement for an agricultural use of the buildings. But that is not, never has been, the correct approach.
But as I understand what Lord Reed is saying, is that the operations within the buildings must be in connection with
Yes.
operations, agricultural operations on agricultural land.
Indeed.
And there is sufficient connection
Yes.
if those operations in the building are reasonably necessary to make the produce or the crop available for sale.
Yes.
But there is a limit, which we don't know what it is exactly, beyond which you cannot go.
Yes. Indeed.
And that, I would guess, is a matter for the evaluation of the Specialist Tribunal. And that's the way I understand Lord Reed's explanation of in connection with.
Indeed, my lord, and that with respect is would be my submission too, and not that one asks, as it were, as a free floating question, is this an agricultural building or is this building in agricultural use? That is to as it were, short circuit or avoid the actual question which the courts say needs to be asked. Lord Reid then takes a step back and tells us at C that it appears to him to be clear from the context and the apparent intention of the Act that agricultural buildings must have been meant to include at least all types of ordinary farm buildings in use when the Act was passed. And as we have seen, when the 1928 Act was passed, free-range poultry farming on a large scale was a form of farming that was then current, that was intended to be caught by the Act. So the ordinary, according to Lord Reid, the ordinary buildings, ordinary farm buildings used to support that method of farming ought to be within the ambit of the Act.
Well, that's another conundrum, isn't it? What's an ordinary building?
Well, whatever buildings ordinarily would be used to
I
support.
mean, is a building which processes 1.4 million eggs from independent producers an ordinary building?
Well, that the question of scale obviously is what has changed, and the fact of being used in connection with other land than the land on the farm. But that's what the 2003 amendment addressed. In terms of the function, Lord Reid is giving us a steer there, and he says it shouldn't be difficult to construe the definitions, including those, and that was the problem in this case, that they were not ordinary buildings because they subverted the relationship with the land. We see this focus on land continue as he construes the words used in connection with at D to F. And he looks first at the linguistic argument, ordinary usage of the English language, and then he has a purposive argument at E and onwards.
At where, sorry?
E on page 154. So, keywords used in connection with ordinary usage of the English language, and then at E, reinforced in my view by the impression it was to benefit agriculturalists. And then at G, he gives his interpretation of those words, noting it's developed in the context of the link between the occupation and use parts of the definition. And he immediately goes on to say that has to be interpreted in a reasonably liberal manner, with reference to a building used to keep store cattle, which would in fact never have gone on the land at all. But he says, well, that would easily fall within the test. So I just stress again, it was not the use test, not meant to be a demanding test where one has a land-based agricultural enterprise, even in 1928, even in 1970. And consistent with that approach at 155C, he rejects the Valuation Officer's argument that the word should be strictly and narrowly construed. In terms of where to draw the line, he comes on to that further down the page, and then taken to the passage. And the feature that Malone and Friend missed out when summarising principles here is that one has to have regard to ordinary and reasonable practice. And that, in my submission, provides a large part of the answer to Malone and Friend's question of how does one adjudicate on which side of the line something falls. Now, broadly, the distinction he was drawing here by reference to the two citations he made was between wholesale sale of produce and retail sale of produce. Now, that distinction, that line may or may not hold good today, where it's much more ordinary for farmers to diversify and have a farm shop or whatever it may be. But be that as it may, in my submission, it is fairly clear that in 1928 or 1970, a free-range egg farmer who was sorting his eggs and putting them into boxes for disposal in the wholesale market would very clearly have fallen within the ambit of the exemption provisions. Now he goes on to consider other authorities which are not particularly relevant. The other speech and of direct relevance to the occupied together with Lynn is Viscount Dillon at page 166. And he, at E, he identifies the two requirements, goes on to make observations about the occupation element. And we note that throughout this passage he is construing those words in the context of the provision as a whole. So he says, just above F, don't think you should find it easy to conclude that the plantation was occupied together with the agricultural land in the sense in which those words are used in the definition. So that is putting them in their context. At the top of the next paragraph, in its context, occupied together with agricultural land may connote more than common ownership. And that context, in other words, the presence of the use requirement in respect of the same land is crucial to the conclusion which follows in the next sentence, which rolls together the two requirements to say, looking at those two requirements together, what the draftsman is trying to do is to define a farm in statutory language. But that reasoning, of course, related to the 1928 Act and indirectly, of course, to the farming conditions in 1928, where farms were still smaller, historic agricultural units. I can pass on now, unless I can assist you any further on that, of course, to Farmer, where we see a similar, my submission, a similar influence from the context. If we start with the Court of Appeal decision on page 178, as my friend did, and just to stress here that in dispute before the Court of Appeal were a provender mill and a poultry processing factory, and we see that there were 67 farms between a quarter of a mile and 120 miles from the mill. And crucial to the understanding the decisions of both the Court of Appeal and the House of Lords is that the Lands Tribunal, we see at E in the head note, had found that these buildings were exempt on the basis that the distance between the mill and the factory and the farms was not a relevant factor. Yeah. So that was what the higher courts were responding to. The Lands Tribunal had applied a purely functional test, and the higher courts were saying, no, we need more of a geographic focus. So there's some irony that the Learned Friend is now trying to rely on these decisions to impose, as it were, an enhanced functional test. We come on at 181 to see the battleground, which is paragraph, so section 2(1)(b), as I said earlier, which is a provision which includes the same link as originally was there in the buildings ancillary to land exemption, namely a link between the occupation and use requirements. Over the page describes what was done in the factory, the sideline passage, which is illustrative to read because it really was quite extensive. The chickens were slaughtered, plucked, cleaned and processed, some of them chilled, a number were boned, the majority were frozen, and then some of them were basted, so injected with butter. So very extensive processes compared to what one finds in the buildings we are looking at. 183 moves on to the occupied together with requirement, and E refers to the passage from Lord Dillon that I've already taken the lordship to, but notes that it's not binding. 184 F to H, he refers to the decision of the Lands Tribunal that my friend referred to, and notes that decision with or that the approach in that with approval, and concludes at the bottom of bottom just below H. So in my view, distance must be a relevant factor. So that was the bright line between him and the Lands Tribunal in that case, and in the other cases that have gone before. And we see that on, if we skip forward to 187. D. The tribunal in this case was saying that the geographical test was not a relevant consideration.
I'm sorry, I've lost you. Where were you reading from?
187.
Yeah.
At D. Mr. Wellington.
D. Yes.
In the Burnham Matthews case and the tribunal in the present case were thus saying that the geographical test was not a relevant consideration, and it fell into an error, which was an error of law. So that's the basis for, in the Court of Appeal, for overturning the Lands Tribunal's decision. He goes on to provide his interpretation of occupied together with in section 122(1)(b) of the 1971 Act, and he sets out those three requirements. First, occupied by the same person. Second, joint control or management of the activities. And thirdly, sufficiently close to be regarded as occupied as parts of the same enterprise. And the second and third of those elements expressly draw on the nature of the common use between the building, the subject building, and the livestock building to which it is ancillary. And so, in other words, informing the construction of occupied together with by reference to the common use requirement. Before leaving this authority, just take you to page 189, where the factory, and there was a live question at this stage about whether the factory was used in connection with the operations in the broiler houses. And the debate, interestingly, was not about the factory itself, it was about the ancillary facilities and the basting operation only. So all the plucking, freezing, deboning and so on were accepted to satisfy the use test by this point, and the only argument is about ancillary activities and basting. And the Court of Appeal did not criticise or seek to overturn the Lands Tribunal's findings that those operations, the basting operation, was reasonably necessary to make the product marketable. And that just goes to illustrate the width of this concept of used in connection. If we move then on to the House of Lords and back directly to the occupation requirements, Lord Slin's speech starts at the bottom of page 195, 197D. It's noted that there's no appeal in respect of the Provender Mill, so the only dispute House of Lords stage was in respect of the factory. My own friend took you through this judgment, so I won't go back to all the references he took your worship to, but just to stress on page 200, we have here the reference to the Scottish case of Midlothian assessor, and where we see that the land valuation appeal in Scotland was concerned with woodlands, and found that they were not buildings thereon. And that was the focus of this Scottish decision. And those words, buildings thereon, are in fact not present in the English provisions. And the reasoning in the Scottish case addressing those words, in fact, goes to the question of B. The relevant question was, what was the unit or unum quid for rating purposes, or in the far more user-friendly language of the English law, what was the hereditament, which is a lot better than unum quid, obviously. Well, I there may have been a hint of irony in my it's in English. But
all the Act tells us is that hereditament means what it's always meant.
Indeed.
And we've got to go trawl through all sorts of cases. Luckily, we've got Woolway now to tell us what it means. It's a very unhelpful piece of legislation.
Yes. But at least it's in English, so that's or nearly. But anyhow, it's the same concept, and that's what Woolway tells us. And so that's what the Scottish court was addressing. It was addressing the hereditament test. And that reasoning was considered helpful and relevant by the House of Lords in construing the occupied together with requirements. And the learned friend says, worse to the effect that it was thought crucially that important for something to that effect. There is clearly an overlap between the two concepts in the mind of the House of Lords, and the geographical focus in that Scottish case on hereditament is part of the support for what the House of Lords says against the Lands Tribunal in this case is required by way of a geographic test. And at 200D, Lord Slin's own reasoning starts. The learned friend has identified that he takes no issue with number points 1 and 2 from Glidewell's list, but on Lord Justice Glidewell's 3, he says, in effect, in my submission, what he is saying is that questions of distance and geography should be looked at not in the context of whether the different elements are parts of the same enterprise, but whether they are parts of one agricultural unit. He says at E, just below E, there's no geographical test which gives a conclusive answer, although that's relevant. And then in the next paragraph, he goes on, in my submission, really to outline in what context and in what way geography becomes relevant. And that is clear from the examples he gives, or the explanation he gives between F and G. So he sets out in the first sentence that what you're looking at is do they form in a real sense a single agricultural unit? And then all of the analysis thereafter is about geography. So if they're close together, that might go far to show they are, but on the other hand, if they're far separate, then it may show they are not. And that is part of the answer to what he was thinking of when he talks about an agricultural unit. The next paragraph gives us further elaboration of that. At H he refers to Viscount Dillon, essentially with approval. And we saw already that Viscount Dillon's speech, the passage in Viscount Dillon's speech, was heavily dependent on consideration of the words occupied together with in the context of the linked use requirement, and in the context of that, the whole sort of package there being to define a farm in statutory terms. And he follows the same logic, the same direction, but says it's no longer right to talk about a farm because of the provisions to derate more agricultural buildings. So 2 points to take from that. Firstly, it's following the same logic and depending on the shared use requirement. But secondly, it accepts that the meaning of occupied together with can change based on the context in which one finds it. So although it may have been right when Viscount Dillon looked at those words to say it's trying to define farm in statutory language, it is no longer right because other things around those words have changed, and so that changes the meaning of them looked at in their context. So that is what one would expect as an orthodox approach to statutory construction, looking at the words in their context. Over the page, he returns to the Act of 1928 and looks at that provision again as a whole, including both the occupation and the linked use requirement, and says that gives the impression of an agricultural unit. So it's the whole provision, the whole thing with the two linked requirements, which produces the impression in his mind of an agricultural unit, in the same way that it earlier produced the impression for Viscount Dillon of a farm. And in my submission, the House of Lords here is not eliding the two requirements as though there were no separation between them. What it is doing is construing the occupied together with requirement in the context in which it finds it, and in that context it imposes a more onerous reading, a more onerous requirement because of the context of the statutory scheme of the 1928 and 1971 Acts than it might otherwise have done. So whilst Malone and Friend is right to say that we are construing the same phrase, the same three words, as the House of Lords did in Farmer, he is not right with respect to say that those words are in the same context. The context has changed, and a crucial part of the context for Eastwood and Farmer has gone, and is now conceded to have gone in the post-2003 legislative scheme. And that is what the Upper Tribunal meant when it talked in paragraph 48 of its decision about the occupation and use requirements being split up And it clearly was, just as the House of Lords was here, aware that they are two separate requirements. But the question in the tribunal's mind was, how do those requirements relate to each other and inform each other? And in my submission, it follows that the Upper Tribunal was right, firstly, to see a connection between the meaning of the use and occupation requirements. Secondly, to observe that there had been a material change in the meaning of the use requirements in paragraph 3 since Farmer. And thirdly, to distinguish Farmer as not applicable to paragraph 3 as a consequence. Now, Malone and Friends' construction accepts that he accepted today, as he did in the Valuation Tribunal for England, but not in the Upper Tribunal, in response to questions from my Lord Justice Lewison. He accepts that the use requirement, as it is now drafted, could be satisfied by a farmer who uses his buildings or the machinery in those buildings only in connection with other land. So he accepts that, but he then says, however, exemption effectively says that exemption would not apply in that case because the occupied together with requirements would not be met. So in effect, his construction is seeking to achieve the same, his construction now is seeking to achieve the same object as the construction rejected by the Upper Tribunal, in that it aims to use the occupied together with requirements to restrict the application of the exemption to a greater extent than was intended by Parliament. If Parliament had intended Malone and Friends' approach to apply, it would have used the words that, or that, and other.
What meaning do you give to the occupation test?
Well, the same meaning that the Upper Tribunal gave to it. That my submissions are directed at supporting that construction at this point.
I mean, on your interpretation, if the egg packing facility had been next to commercial woodland, it would be exempt. All right? Because that's agricultural land.
Well, there is the point about the same enterprise. So if they were totally different enterprises, if it was used for a completely different purpose altogether to the surrounding agricultural land, then that
would be the same hereditament.
Well, not necessarily if it were used for a completely separate purpose, because that's coming on to my hereditament argument. But the Upper Tribunal said it needs occupation by the same person at the same time, as part of the same enterprise, and geographically close, if not contiguous. And that gives meaning to, linguistically, that gives meaning to everything, all of those words, and it does so in a way which goes with the changed context rather than against it. My Lord, unless I can assist you any further on that point, it's 3 minutes to 1, so perhaps.
Right, all right. Well, we'll stop there and resume at 2 o'clock.
Court